Pictures like that are pretty familiar to us. We see them all the time in films, television programs and the news. A crime is committed, the police make inquiries, they speak to witnesses, take statements and gather evidence, and then someone is arrested and driven away in a police car. But then what? What happens next? Cameras are not allowed inside courtrooms, and so what happens inside one is to most of us a complete mystery. But many of us may at some point have to attend court. We might be there as a witness or victim of crime, perhaps to serve on a jury. You may even find yourself in court on trial as the accused. A courtroom is a very formal and traditional place which can at first appear frightening and very complicated, filled with people wearing strange wigs and gowns and using words and language which most of us don't know or understand. Well, this programme will unravel some of the mysteries, explain the procedures and reveal what happens behind these doors as we follow the progress of a case through the Scottish criminal justice system.
A case typically goes through 4 main stages. Stage 1, the arrest and court appearance. Stage 2, preparing for court appearance. Stage 3, attending court, the trial. Stage 4, sentencing. After an offence is committed, statements are taken from the victim and witnesses. The police then investigate and gather evidence. Once a suspect is identified, an arrest is carried out and the suspect is taken to the police station and locked in a cell prior to interview.
Everyone accused of a criminal offence in Scotland has the right to a solicitor and may be entitled to free legal advice. The police can keep a suspect at the police station for up to 6 hours. The police must tell Darren that he has been kept or detained, and it's at this point that Darren may request a solicitor to be told that he is in the police station.
Darren can either use a firm of solicitors that he or his family knows or has dealt with before, or the police will contact one on his behalf from a list within the police station. Solicitors are completely independent from the police and the rest of the criminal justice system. A solicitor will be able to give Darren advice on the legal system and its procedures, and if necessary, represent him in court.
At the end of 6 hours, the police must tell Darren if he has been charged with an offence, and if not, he must be released. Darren has been charged with assault and robbery and will appear in court for the first time the next day. Once someone has been charged with an offence, the police continue to make inquiries about the crime and gather evidence. But the decision to prosecute a case is not made by the police. Their job is to detect crime and carry out initial investigations. The decision of whether to prosecute or not is made by the Procurator Fiscal Service.
The service has responsibility for the investigation and prosecution of crime on behalf of us, the people of Scotland. During a news report, you may have heard a reporter say, "A report has been sent to the Procurator Fiscal." What that means is a file which contains all the information about a case, including statements and evidence, is passed by the police to a Procurator Fiscal. The Procurator Fiscal, like Darren's solicitor, is a lawyer, but her job is to prosecute cases. Each case is unique and must be considered on its own facts and merits. The Fiscal will look very carefully at the case and consider if the right person is being prosecuted for the right offence.
There are a number of options available to the Procurator Fiscal. They may decide to issue a warning or a fine for minor cases. They may think that more evidence is needed and ask the police to carry out more investigations. Or they may decide not to proceed at all. In Darren's case, they have decided that there is enough evidence and will begin criminal proceedings against him.
Darren intends to plead not guilty to all charges, and so the defence team will also make their own investigations. This will probably include talking to police officers, the shop assistant, and others who were in the shop at the time of the robbery. Darren's defence team will also begin to interview witnesses who will give evidence for the defence. These are the people who may be able to back up Darren's side of the story. For example, by saying he couldn't have carried out the crime because he was with them. There are three main types of witnesses. Witnesses for the prosecution, those who saw the accused carry out the crime. Witnesses for the defence, those who do not agree with the version of events put forward by the prosecution. And expert witnesses. These are people who probably had no involvement with the crime, but have expert knowledge of a subject, for example, fingerprints or DNA.
In Scotland, criminal cases can be prosecuted either summarily or on solemn procedure.
Summary trials are conducted before a judge. The judge decides on all questions of fact and law, and they alone decide on guilt. There is no jury.
Summary trials are the most common form of trial in Scotland and are a quick and efficient means of administering justice.
Solemn trials involve a jury of 15 people, randomly selected from the community, and are conducted for more serious crimes such as robbery or murder.
Darren's trial will be conducted on solemn procedure with a jury and will take place in the Sheriff Court.
Many people are involved in a solemn trial. A sheriff will be appointed to preside over the case. A procurator fiscal will lead the case for the prosecution. A defence solicitor will represent the accused. Witnesses are required, and members of the public who may become members of the jury.
With only a few exceptions, everyone in Scotland aged between 18 to 65 may be asked to sit in a jury.
Jury service is an interesting and important public duty. It gives ordinary members of the public the opportunity to make a vital contribution to the administration of justice in Scotland. The Scottish court system provides courts at 3 levels to administer criminal justice. The district court deals with the most minor cases, such as traffic offences or shoplifting. All cases at the district court are conducted on summary procedure. No jury trials are possible at the district court. Most large towns in Scotland will have a district court which are run by local councils. The Sheriff Court deals with more serious crimes such as drug offences and housebreaking. The Sheriff Court can hear criminal cases either with or without a jury. The judge who presides over cases is known as a sheriff. We'll tell you a little more about the sheriff and their duties a little later on. The most serious of criminal cases, such as murders, are held in the High Court. All trials in the High Court are heard with a jury.
This programme has looked at the first 2 stages of the criminal justice system in Scotland, the arrest and preparing for trial. In the next programme, we'll take a look at what actually happens inside the court as Darren's trial begins.
Many of the people who pass through these doors today will probably never have been in a courtroom before. Witnesses, potential jurors, victims, people accused of an offence will all probably feel a little bit anxious about what lies ahead. But for some, attending court is an everyday occurrence. In fact, it's their job. Everybody here is very familiar with the courtroom and the procedures. The prosecution team and the defence are able to chat and joke with each other whilst they prepare for the trial ahead. And the officials of the court make sure that everything is in place to allow the trial to begin on time. Physical evidence, such as the clothing and the videotape from the CCTV, is known as label production. Written evidence, such as statements or fingerprint evidence, is called a documentary production. The clerk of the court checks that the equipment inside the courtroom is working properly. The televisions may be needed to watch the video from the CCTV. In sensitive cases where younger children are required to give evidence, the child often sits in another room and their evidence is relayed into the courtroom via the TV screens. This can spare the child the ordeal of being in a courtroom full of strangers. The whole trial has to be tape recorded. This allows evidence to be re-listened to if there is a dispute about exactly what a witness has said. Whilst everyone here is getting ready, the sheriff is preparing away from the courtroom in an area known as chambers. The title of sheriff is a very ancient one, dating back almost 1,000 years. It comes from the words shire, meaning area, and reeve, which means the king's representative. Back then, sheriffs carried out the wishes of the king, acting as judge, local administrator, military officer, and tax collector. As well as presiding over criminal trials, sheriffs today are also required to carry out a lot of other kinds of legal work, including authorising search warrants for police officers, finalising adoption, divorces, and overseeing fatal accident inquiries. Sheriffs have a very important role in the criminal justice system. They need to be experts on the law and to ensure that each case is judged in a fair and balanced way. Although sheriffs will have spent many years as solicitors or advocates and will have a wide knowledge and expertise about the law, a library of journals and books are provided to help them interpret the law in an impartial way. Court normally begins at 10 o'clock. In some courts, people who enter have to go through certain security procedures, similar to those you may have experienced at airports, to make sure they are not carrying a weapon or concealing a camera, as you are not allowed to take pictures in a court. Each of the different participants in Darren's trial will be told where to wait. All witnesses, like the police officers and the shop assistant, will be shown to the witness room. Witnesses for the prosecution wait in separate rooms from defence witnesses. Potential jurors will be asked to wait in the courtroom where the trial is to take place. Also in the court may be the accused waiting for the trial to begin, families of those involved in the trial, members of the press, and members of the public. Anyone over the age of 14 is allowed to come to court and watch proceedings, but school children under 14 years may be